in an ongoing proceedings, if a defendant does not appear in a hearing, the proceedings will likely to proceed ex parte, that is in his absence. So what is the result? The answer will shock you, because in this video I will be sharing a very critically important legal principle that even being ex parte, the defendant can participate in subsequent proceedings without the permission of the court. That is, there is no need of filing any application also for setting aside the ex parte, which most of the litigants are doing today, and because of that, courts are also putting huge cost upon them. So how to save those costs? Let us see in this video. So the relevant provision of law is Order 9 Rule 7 of the Code of Civil Procedure 1908. This provision states that if a hearing is conducted ex parte, that is in the absence of the defendant, and on the subsequent hearing the defendant appears and satisfies the court with a good cause of his absence, then he may participate in the proceedings on the terms put up by the court, which may also include the cost. Now this provision has led to conflicting interpretation amongst the court for years. One interpretation is that the defendant cannot participate in the subsequent proceedings unless a good cause has been shown to the court by the defendant and that order of ex parte is not set aside by the court. This view was upheld by Rajasthan High Court in Sevaram versus Misrimal case. The court ruled that once an ex parte order has been passed, the same remains in effect till the conclusion of the proceedings. And the defendant cannot participate in the subsequent proceedings also unless that ex parte order is set aside as in accordance with the law. But there is other view also. The other view holds that the defendant's absence at a particular hearing does not render him ex parte for the rest of the hearings, rather only for those hearings in which he was absent. Consequently, he can appear and participate in the subsequent proceedings provided he do not want to challenge any order or any action made in his absence. This view was upheld by the Allahabad High Court in the case Bhagavat Prasad Tiwari versus Mohammad Sibli. In this case, the High Court ruled that even if the defendant has been proceeded ex parte, he can participate in the subsequent proceedings without any restrictions. Now, this is a big conflict because the law is same, but there are two different views upon the same. So this was ultimately solved by the Supreme Court in its full bench ruling, Sangram Singh versus Election Tribunal. Although this ruling dates back to year 1955, but it's a landmark ruling and has been referred and followed in various other Supreme Court rulings. One such ruling has come upon in 2018, that is Sikar Kendriya Bank Limited versus Bhagirath Singh. So what has ultimately happened in Sangram Singh versus Election Tribunal case? The Supreme Court clarifies that the ex parte is not mortgaging the future. Rather, it applies only to the hearings in which the defendant did not appear. So the defendant can appear and participate in the subsequent proceedings without any impediment, provided he accepts the outcome of the earlier proceedings. If he wants to challenge those proceedings, he can show the good cause under the provisions of CPC, that is Order 9 Rule 7, and gets that order set aside. In simpler terms, if there are 10 hearings in a proceedings, hypothetically, and the defendant did not appear in the first 4 proceedings, and he wants to appear in the 5th proceeding, he can appear without any restriction. But it will be deemed to be understood that he has no dispute with the earlier 4 proceedings. If he wants to challenge any part of the earlier 4 proceedings, he had to show and satisfy the court with the good cause for his absence, all those proceedings. And once the order of ex parte is set aside under the Order 9 Rule 7, he may challenge the same. But for participating, there is no need of putting an application. So the law is clear. A defendant, even being ex parte, do not need to file an application for setting aside an ex parte for participating in the further proceedings. So in the end, I would like to put upon a question to you on which I want your opinion. That does this interpretation of this law unfairly disadvantages the plaintiffs who are vigilant, or does this interpretation ensure justice for the defendants who could not appear in the proceeding? I shall wait for your opinion in the comment box. Thank you.